Our first speaker today is Leon Castellanos Jankiwicz, and he's a researcher in international law at ACER Institute and academic coordinator of the Netherlands Network for Human Rights Research. He has held numerous prestigious fellowships and achieved several awards, and today we will listen to his presentation about the national international law, the minorities treaties, and municipal legal personality. So go ahead, the microphone is yours.
Thank you so much for the very kind introduction, and thank you so much to the organizers and to Boris for having me here today. It's very special for me to be here because, full disclosure, I am a lawyer. I specialize in international law, and being among historians is a great honor, especially for someone who has a bit of a different training, but really the same interests. And so I hope that this is interesting to you. So, just to explain a little bit of the change in the title, I think now, yeah, that's good. Harnessing Adjacent Possibility from Nationality to Early International Rights. The premise of the paper starts with the idea that private international law is internationalizing rights, is being used as a vessel in order to project rights to the international space. And the way that happens is through the idea of nationality, which in the 19th century is a dominating idea in terms of how civil codes are being developed, but also how those civil codes are being applied across borders. And so in developing this project, what I'm interested in is ultimately I'm trying to explain how international rights and international human rights reach international treaties and are codified in international instruments in the, starting in the 1940s and the 1950s. But I'm really interested in the second half of the long 19th century because I believe that the debates about nationalism, about nationality, have a huge impact in the development of international rights. Now, this is nothing new to you, but when it comes to identifying the ways in which those rights have been projected, this paper specifically is trying to use private international law as a way of trying to follow those trajectories, and this is what the contribution the paper is trying to do. So the paper begins with a story about a memorandum that is written by the Secretary General of the League of Nations in 1921 in the aftermath of the Russian Revolution. And here, the Secretary General, this is from the League of Nations archives, which are now happily completely online. I believe now they've finished the digitization project very recently. I think you just need to sign up in order to get access, but it's free. It's wonderful. They did a wonderful job over the past 3 or 4 years. So the memo is identifying a problem with the Russian refugees. A couple of million of them are already in Europe, and the courts in Europe don't really know what to do. What is the problem? A lot of these Russian persons, former subjects of the Russian Empire, are stateless, are denationalized, and but they continue to do business, they continue to get married, they try to keep hold of their personal belongings and personal relations, marriage status, etc. But the courts in Europe don't know what law they should apply. By the rules of private international law, they should apply the law of nationality. Most countries on continental Europe applied the law of nationality, that is the law of citizenship. But the Bolshevik laws had disenfranchised many of these persons. And so, because of the abolishment of private property, etc. So the French courts or the Spanish courts, etc., they could not apply the principles of private international law to recognize those rights. So essentially what they did was to pretend that the imperial laws were still in force so that the continuity of legal relations could be ensured. The European courts pretended that the revolution never happened, essentially, virtually. And so, the way in which they arrived to this decision was through the recommendations and expertise of a German scholar, but also diplomat. One of my colleagues on the panel is going to speak about him as well, Andre Mandelstam. Mandelstam is an interesting figure for private and public international lawyers alike. He was a diplomat ascribed to Constantinople. He was an expert in Russian and Turkish relations, and an expert in terms of the civil law system and how it applied in Turkey. And he was commissioned by the Secretary General of the League of Nations to issue recommendations as to how the Russians should be treated in Europe. And so we'll be hearing more from Mandelstam towards the end of my presentation, because he's also very important in the lead up towards drafting the main human rights, the legacy human rights instruments that essentially launch the career of human rights in the international sphere during the UN era. So just a few key points about private international law and how it relates to this project of which this conference is about. So essentially, private international law, or conflict of laws, as it is also known, is a system of rules of recognition to determine the applicable law to a particular situation. And so by choosing applicable law, you also choose, or you also recognize rights across borders. So private international law is associated to status, personal status rights, closely related to nationality in the 19th century and citizenship, and it is also generative of rights. So even though it is, rules that determine applicable law, depending on which law you end up applying, you can actually enfranchise or disenfranchise someone. So private international law is doing a lot of work in terms of rights allocation in the second half of the 19th century. And so it creates the adjacent possibility for deterritorializing rights. And so it's not anchored, of course, in an NTA rationale, but nationalism does play a role in the development of private international law in the 19th century, as I will show in a few slides. So maybe we could think about, the role or the work that private international law is doing if we, transpose it to the NTA analogy. Maybe it's a national personal autonomy instrument, like as was being discussed by the colleague from the Russian university that preceded me in a very interesting presentation. And so, the idea of private international law is predicated on the fact that personal status and rights move, and so there is also an extraterritorial dimension to it. And so that in a way that nationality will determine your status abroad and will determine which kinds of rights you enjoy abroad. And so personal private law rights are transposed to the international state-based system through private international law. And then we will see that these rights are, so to say, condensed into a series of principles towards the end of the 19th century and re-enter national law as normative guidelines that are then going to turn into human rights. Okay. So who am I looking at? Who am I talking about? What are the actors? What is the situation? Mainly the paper is following the debates and discussions of a bunch of men, because there were only men members of the Institute of International Law, which is founded in Belgium, in Ghent, in 1873. Still active, storied institution, grand institution, very prestigious, if you remember. And this is their kind of oldish website. And here they feature their 1904 Nobel Peace Prize. It was the first international institution to be awarded the Nobel Prize before the Red Cross. And here is just a letter from the founders of the institute to King Leopold II. So a lot of these members of the Institute, they were drafting constitutions, they were working in foreign ministries, they were advisors to governmental officials, but they were also heavily involved in the colonial and imperial enterprises. And now there is a lot of work in the field of the history of international law trying to uncover and to reveal those connections between imperialism and colonialism and disenfranchisement and the concepts that these people were advancing. But for the purposes of this presentation, we're looking into how the debates that they had on private international law were then projected into other areas of international law. And here, there is a couple of, there's a lot being written on this, but these would probably be the two books if I were to pick two great books that are current and recent and talking about these ideas. Roxana Banu's fantastic 19th century perspectives on private international law, published in the Oxford series on the history and theory of international law, which essentially, she tries to debunk this myth, which says that, public and private international law were always separate, were very distinct disciplines, and so have always developed independently. In the 19th century, this is not the case at all. And even today, we still see some rapprochement and some, commonalities in how private international law deals with human rights, and how, and vice versa, and how private rights are also affected by public law. So that's Roxana Banu's book. She's trying to show that it's much more complicated than that. And I find that really important for my argument because I also rely on this idea that it's really messy in the 19th century. This disciplinary exchange is very, very rich. And we see that there are lots of discussions that are overlapping between the two disciplines. And can I just check on my time right now? How? 9 minutes left. Great. Thank you. And the second book is by Chris Casey, who is, Roxana, I think, is in Queen Mary University, London, and Christopher Casey is at the Library of Congress in the United States, and also he's affiliated to a liberal arts college. I cannot remember which, but a fantastic book called Nationals Abroad, Globalization, Individual Rights, and the Making of Modern International Law, focusing on the protection of property of aliens abroad. So Chris is what he does, it's almost a literary book. It's a beautiful read. If you haven't, you should check it out. Is looking at this from the perspective of European investors, European people who have holdings and property in extra-European spaces, but also intra-European spaces, and how law is being used and international legal standards protecting individual rights are being developed through the protection of these private property claims. And so I want to engage with these premises because what I present in this paper is essentially a combination of these two arguments, that private international law is also doing a lot of heavy work and heavy lifting in terms of projecting rights to the international sphere. So a couple of words I want to say about the usual human rights narratives that we have. Then I will just dive into the paper and talk about the legacy of nationalism, reciprocity, and comity, which were the systems of rights recognition in the 19th century, the development of an international minimum standard of treatment of foreigners, and then just perhaps conclude with some ideas regarding human rights as a global private law system. We always think about human rights as public law, but if we can reimagine or recover this legacy of private international law and the protection of private rights through international standards, perhaps there is an alternative story of how human rights law came to be through the lens of the private, as opposed to exclusively the public or the constitutional, and so on. Okay, so, human rights are individualistic things. We have Marty Koskiniemi, Christian Tomushat. They're individualistic ideas that came out of the horror of the Nazi dictatorship, etc. And we know, of course, that from work of Marco Duranti or others, that this is a very reductivist way of looking at human rights. And this would be your usual timeline. You look at the United Nations, 1945, individual rights, constitutions, public law. And I want to challenge this narrative. I use this communitarian challenge. Sam Moyn has talked about it in his last Utopia, kind of in passing. And then Hannah Arendt, equality comes from belonging to a community and enfranchising each other. So for this, we would have to look a little bit further back, start in 1873 with the Institute of International Law, look at the influence of nationalism and how private law and private rights are projecting that nationalism abroad. So my argument proceeds in these three steps, and in the next 5 minutes, I'll just walk you through them. First of all, we have codification in Europe, which sharpens the distinction between national and alien, right? And civil codes are being drafted, from the late 1700s to the mid 1800s, and this distinction is pretty fluid up until then. And then conflict of laws determines which kinds of rights you get to have across borders on the basis of reciprocity and comity. Now, reciprocity and comity are based on the will of the state. So they're not really rights that are held by the persons themselves. They're rights that are granted by the state out of the goodness of their heart because they have good relations with their neighbors. But then, as the legal standards grow and more civil codes develop, we start to see minimum standards of treatment that everyone has to abide by because the reciprocal agreements are too numerous and they're too diverse. So, the reciprocal relations between France and Austria are not the same as the ones between France and Spain. And so, when people move around so much, what kinds of reciprocity can you expect? It gets complicated, so let's have some minimum standards. And so I just explained the reciprocity comity. So minimum standards, so these people in the Institute of International Law, they start to realize there's so many civil codes, and there are as many standards of treatment as there could be civil codes, and you can do permutations of that. And so there's legal uncertainty as to what kinds of rights people enjoy when they're moving around. So Henry Wheaton, very important book at the time, there's no uniform and constant practice of nations as to taking cognizance of controversies between foreigners. Felix, who is a privatist, very important textbook that was relevant in France for about 30 years, even 20 years after his death. The key question, he says, is whether nations will recognize the authority of common and overarching principles. And the solution to the overarching principles comes from the principle of nationalities, which Pasquale Stanislao Mancini adopts in the Institute of International Law in 1874. Irrespective of treaties, reciprocity, or comity, we have an international standard of justice that needs to be constructed. And this is still very vague, but he puts it in the first resolution of the Institute that is held in Geneva. The session was held in Geneva. And he says, we need to recognize the civil rights of aliens. And these rights are derived from personal status, nationality. His contemporaries, Charles Demonjas, this is the first issue of the Journal du droit international privé, also edited by Mancini. The first article of the first issue of the Journal of Private International Law, 1874, Demonjas says, above and beyond, this is a kind of manifesto, right? Above and beyond the civil codes which have been issued by governments, there exists a certain number of general principles whose binding force is equally recognized and applied among all peoples. And so, again, private international law sort of being crafted in this vision of rights recognition across borders. So I have 2 minutes, so hopefully I can drive you home now with this last idea, which is important for the paper. So I've been talking about private international law, but private international law is also propelling private rights. And so what are these principles that Demonjas is talking about here? Well, it's a series of private rights, private civil rights, they were called, droits civils internationaux, as opposed to public rights. So public rights or political rights, that was the usual division. Civil rights and political rights. Today, human rights lawyers talk about those two categories in the same breath. So you have the Covenant for Civil and Political Rights and the Covenant for Economic, Social, and Cultural Rights. most important human rights instruments that are binding in the UN system. 19th century lawyers would not recognize this. Civil rights are protection of bodily integrity, property, and liberty. And then political rights are, voting, being a citizen, and so on. But so foreigners could enjoy civil rights. And actually, there are lots of initiatives brought into the Universal Declaration drafting. The French member, René Cassin, he says we need to have droits civils internationaux, universal private rights recognized in this draft. He failed. But what were they? Okay, so here we have Hefter, another important international lawyer, arguing that the private rights of man are the primordial ones. No mention about human dignity, no discourse about, natural law or anything like that. It's about private law, private rights. Same thing, 1880, by Laurent. He talks about, we can exclude people for political rights, but private rights, everyone should have those as well. So, can we rewrite a history of international law or human rights law through the lens of private rights? I think we can. If we look at those examples that I just gave, and if we look at the work and trajectories of some of the actors who were populating the Institute of International Law, and who were later on involved in the drafting of the most important human rights declarations and human rights treaties. For example, here we have two of them, Mandelstam and Cassin. These two persons, Mandelstam is the drafter of the 1929 New York Declaration on Human Rights, probably the first modern human rights declaration that was ever written. He's an expert in private international law. And René Cassin was also a conflict of laws expert before he had a great career, which got him the Nobel Prize as the drafter of the Universal Declaration. So there is, I think, room to write in the register of private law. This is the New York Declaration. And of course, the idea of nationality ends up being transposed in the language. And I conclude with this, with Eleanor Roosevelt. Since I've been talking about men this whole time, I think it's fitting that she regards us with suspicion here. The word national in Article 2 of the Universal Declaration, making reference not to citizenship in the sense of, holding a passport, but if you go to the travaux préparatoires, the word national there is making reference to ethnic nationality, and that's the actual meaning of that. So we see, a direct line from the national identity projecting international rights through private international law in the 19th century, and the Universal Declaration using national, of course also through the influence of the minorities treaties of 1919, in an ethnic sense, not in a citizenship sense. So with that, I would like to thank you for your attention, and I look forward to the next presentations.
Our next presenter is Tatiana Khripachenko. Tatiana received her PhD at the Central European University, and in her dissertation she analyzed the concepts of autonomy and federation in the liberal discourse of the Russian Empire. And recently Tatiana started a postdoc at History Institute of University of Bonn, and her new project is devoted to the entanglements between the Soviet and Russian emigrant discourses of international law. And today Tatiana will focus on the uses of non-territorial autonomy in the projects of Russian legal scholars. So Tatiana, the floor is yours.
Thank you so much, Timo, for a detailed presentation, and I'm very happy to be there again and be a part of this fascinating and inspiring discussion, and I'm happy that I can also contribute there. Thank you so much for invitation. At the same time, as Timo said, I'm studying a project on international law, and right now it's quite difficult to reflect on these issues in the time of the terrible war of aggression by Russia against Ukraine and many serious violations of international law. And I always keep in mind current events when thinking about earlier Russian legal scholarship. In my today's presentation, I will consider the cases of imperial uses of non-territorial autonomy in the Russian Empire. These are the projects of two Russian international lawyers, Andrei Mandelstam and Boris Nolde, who are more famous for their work in the League of Nations and their ideas on the status of international protection of refugees and also the protection of minorities. Yet today I will speak about their earlier projects in which they used the ideas of non-territorial autonomy, yet these ideas served rather a larger goal of imperial domination and pursuing the policies of establishing control over the neighboring empire or retaining the borderlands of one's own empire. The first, the project of Andrei Mandelstam was a plan of reforms for the protection of Armenian minority in the Ottoman Empire. And the second project by Boris Nolde was initially presented at the meeting of the Cadet Party in July 1917. Although written in different contexts, both projects are indirectly related with each other. Their authors are close friends who shared a lot in their intellectual and professional lives. Both of them came from non-Russian families, and in different years they received education at the law department at St. Petersburg University from the same professors, and they wrote their dissertations under the supervision of Fyodor Martins, quite a famous international lawyer. They continued their professional careers at the Ministry of Foreign Affairs and worked together in many commissions. In particular, they were both involved in organizing the Second Hague Peace Conference in 1907. They read and discussed each other's works. However, it is hard to trace the channels through which they adopted Austrian Marxist ideas, yet they never referred to them directly. That the evidence attests that they were quite familiar with them. They regarded non-territorial autonomy as a kind of a civilized way of treating the issues of minorities. In one way or another, they inherited many assumptions of the European discourse of international law and the ideas of the standard civilization, and also the ideas of possibility of restriction of sovereignty of states on humanitarian grounds. And many recent studies emphasize the reproduction and the continuity of these ideas in the post-World War I international order and also in the League of Nations minority treaties. Therefore, at the same time, the very form and the very discourse in which these projects were presented provide some ground for regarding them as earlier precursors of League of Nations practice of protection of minorities. And it is interesting to see how the ideas of non-territorial autonomy or non-territorial arrangements appear in this context. The project of Andrei Mandelstam resulted from the International Commission initiated by Russia in 1913 to protect Armenians in the Russian Empire. The issue has quite a long history dating from 1878, when a special provision on the protection of Armenians was fixed in the Treaty of Berlin. Traditionally, Armenians resided non-compactly in various parts of the Ottoman Empire and were organized within a special millet with a religious center in Constantinople. They enjoyed some form of self-government in the sphere of religion, culture, education, and economic issues. In 1863, they adopted a special Armenian constitution which defined their millet community as a nation and introduced some secular elements into secular forms of self-government in self-administration. At the same time, they were in a vulnerable position as they suffered oppression and violence from Kurds. The situation became even more serious when so-called Hamidian massacres took place in 1895 and 1896. They were quite bloody massacres, and so to protect the population, France, Britain, and Russia created a special commission to work out a special plan of reforms for the Ottoman Empire, but it was suspended by Russia. The attempts were renewed in 1913 when Turkey was defeated in the Balkan Wars, and there was an expulsion of Muslim population from the lost territories, and the Ottoman government responded in the renewal of oppression against the Christian population inside Turkey. So Mandelstam chaired the commission, and his plan supposed to create a special territorial province of 6 vilayets with Armenian population. On the map, it is outlined the territory of this proposed province. However, within this province, the Armenian population did not live compactly. It was, they lived quite densely, but they were not living compactly in this territory. The province was carved out from the rest of the Ottoman state institutions and was directly subordinated to Sultan. It was supposed that international inspectors would observe the reforms and the situation within the province. The province acquired its own legislation, and Mandelstam proposed the idea of an equal representation of Christians and Muslims, both in administration, courts, police, and representative bodies. Finally, he included the Article 16 into his project, Article 16, offering some elements of non-territorial autonomy. The article provided each ethnic community with the right to levy taxes from the members of the community to hold and administer their schools. These provisions distinguished Mandelstam project from the previous plan of reforms, which offered only functioning of special norms in this region and mainly referring to the organization of justice. A further consideration of this project in the International Diplomatic Commission resulted in certain changes. The representatives of Germany and Austria-Hungary insisted on implementing a proportional principle of representation of ethnic groups in provincial institutions, and it was also agreed that non-Muslim ethnic communities would receive the right to compose their own list of voters for the elections to provincial institutions. In general, one could trace a certain influence of Karl Renner's ideas and some Habsburg practices of non-territorial autonomy in the Habsburg monarchy, despite that neither the term non-territorial autonomy nor the names of Austrian intellectuals are mentioned in the project of Mandelstam. At the same time, the project presupposed international supervision and a substantial restriction of sovereignty, which Mandelstam justified with the theories of humanitarian intervention. Thus, it followed from the project that non-territorial autonomy was perceived as a kind of a civilized way of managing of diversity in the region. Now I'm moving to another project, another case of the project of Boris Nolde, and the following quotation probably conveys the general tone of his project. Russia should be aware of so many things related to its desire to impose nationality on its diverse nationalities, which lived on the territory of Russia. Therefore, it has no right to pass on this negative mission to its other privileged national groups. So, recognizing Russia's mistakes and pitfalls in treating nationalities, Nolde at the same time assumes that the presence of even negative experience makes indivisible Russia more mature in its relations with the diverse multinational population. Boris Nolde's project was a reaction to a proliferation of national claims after the February Revolution, and to a greater extent to the agreement of June 1917 between the provisional government ministers and the Ukrainian Central Rada regarding the autonomy of Ukraine. In protest to this agreement, the cadet ministers left the government, yet the next day they recognized or included the slogan of autonomy into Ukrainian autonomy into their political program. At this moment, Nolde combined his membership in both in the cadet party and also in the provisional government. He was a legal expert in a special juridical commission of the provisional government. At the same time, the argument between the cadets and the leaders of the Ukrainian national movement had a rather long story. From the very beginning, the cadets refuted the Ukrainian claims for national territorial autonomy, among other things referring to the ethnic diversity in the region. In his turn, Mikhailo Hrushevsky, the leading spokesperson of the Ukrainian movement and later a head of the Central Rada, considered positively the idea of providing cultural rights to all nationalities within the autonomous Ukraine. Mobilization of the Ukrainian movement in 1917 and the creation of the Central Rada was an unexpected challenge both for the cadets and the provisional government, not only Central Rada acquired large support of the local population, its claims for autonomy also acquired new tone because they enveloped the idea of kind of a semi-independent Ukraine with a loose link to Russia. Nolde's concern about this agreement between provisional government and the Central Rada referred to the situation of non-Ukrainian citizens within the new autonomous Ukraine. He feared that they might not be properly represented in the Ukrainian institutions. And in July 1917, he and Kokoshkin co-authored a temporary instruction of the provisional government to the General Secretariat. This instruction actually limited the Ukrainian autonomy and proposed the position of a secretary for nationalities with the deputies, each representing most numerous nationalities in Ukraine. His project of non-territorial autonomy, Nolde wrote almost at the same time, and one can even see how some rhetoric cliches go from one of his texts to another. And in his project, Nolde opposed non-territorial autonomy to national territorial autonomy. He described national territorial autonomy as an imperfect way of treatment of national question. By contrast, non-territorial autonomy offered more advantages in terms of national equality. According to Nolde, non-territorial autonomy had its history in the Russian legislation, and he referred to the cases of Armenian church in Echmiadzin, which extended its influence to all Armenians, even beyond the borders of Russia. And he also referred to a case of the Georgian autocephalous church. Therefore, it was important for him to open up, but in fact invent Russia's own tradition of non-territorial autonomy. In this way, he is thought to emphasize Russia's allegedly more advanced way of accommodating diversity as compared to its potential territorial units carved up along national principle. At the same time, one can see how he downplayed the presence of the ideas of protection of minorities among the representatives of the Ukrainian national movement and the reaction of the leaders of the Ukrainian movement and Ukrainian newspapers is quite telling there. The most influential newspaper, Vestnik Союза Вызволения Украины, wrote that in response to Nolde's project, wrote that they accept the idea of non-territorial autonomy for national minorities on the territory of Ukraine. But the Ukrainian people would not, but non-territorial autonomy would not satisfy Ukrainian people because Ukrainian people has its own claim of a statehood status of Ukraine in a federal link with Russia, and they will never give up. So I'm going closer to the conclusion, my first point is that although the projects were written for different contexts, they shared many common features. Both of them were written from the position of imperial domination and perceived Russia as a civilized power standing for the oppressed minorities. Mandelstam sought to justify this role with legal theories of humanitarian intervention, Meanwhile, Nolde referred to Russia's historical experience and sought to invent Russia's own practices of non-territorial autonomy. Thereby, he sought to prove that Russian imperial authorities had more advanced way of achieving national equality than the idea of national territorial autonomy. No, probably I'll stay there. Thank you.
Our next presenter is Simon Rabinotich. He's the Stotsky Associate Professor of Jewish Historical and Cultural Studies at Northeastern University in Boston. And his books include Jewish Rights, Nationalism and Autonomy in Late Imperial and Russian Jewry, which many of us are probably using in our research. And currently he's involved in a bigger project that he calls the Group Rights Project, and this very project is the one about which we are going to learn more. So the floor is yours.
Thanks so much. This has really so far been really wonderful for me. I've learned an enormous amount that I'm going to carry forward with me for this project and other projects. I mentioned in the abstract, I mentioned that I was going to discuss several court cases relating to Jewish collective rights and that it also demonstrate this new digital tool I'm working on. But in putting the presentation together, I really realized that this was one or the other, but I really wouldn't be able to do both. So I've chosen to focus on this digital tool because I think it's something different and something that also might be of real interest to the scholars of this conference and hopefully use as well once it's launched. So to give you a little bit background on how I came to this project, how I thought about it, I'm currently working on a book that compares court cases and policies in different countries where Jewish collective and individual rights have been at odds. And there are a couple of main arguments of this book. The first, there's sort of two axes I'm grinding. The first is that Jews have established forms of collective rights and indeed non-territorial autonomy, even if it's not framed that way, in many different contexts, including within liberal democratic states. That's the first argument. And then the second argument, I'm revising something that it seems that we're all revising here, so it doesn't seem terribly original, but I guess we all know that in our other contexts that sometimes there is resistance to this, which is that that in the development of modern states, the idea in sort of the prevailing theories of state modernization and state development is that the individual rights come to reign supreme and the collective or corporate rights sort of fall away, or maybe they become transformed into political rights, right? Political rights and the nation state becomes sort of the new form of collective rights. And in this book, I'm arguing, well, yes, that's true, but wait, right? That collective rights persist in different forms all over the world, all over the world today. And like I said, this is probably an idea that has a lot of sympathetic ears in this audience, but you probably also know that this isn't the way a lot of people look at things. So the book looks through specific examples and especially court cases where individual and collective rights are in conflict. But I was thinking about the limitations of my argument, actually. It was actually, I had a trip, the pandemic was going on, and I had sort of gotten money for a trip to do some research, and then of course I had to cancel it, and I was thinking one day about this other question, which is, I'm making this argument about the persistence of collective rights using the example of Jews, right? And I'm saying, look, they exist, they continue to exist in other forms all over the world. And then I thought to myself, but how do I demonstrate that, right? So I make write this book, and I have all sorts of examples. But then I was sort of saying, well, and look, they're everywhere. Well, how do I actually demonstrate that? And that made me think, well, that money that was going to go to that trip, maybe it'll go to something else instead. And I had this idea about mapping Jewish collective rights, right? What if I actually tried to create a visualized tool, or a tool that would help us to visualize how the world looks today, right? And so these were my sort of three purposes, right? If I'm going to hire grad students to work for hundreds of hours, I should have a reason. And the first was to visualize legal systems and how they're distributed. The second, I want to demonstrate sort of the diversity of legal arrangements. And the third was to provide an encyclopedic resource that if you wanted to know what the legal arrangement that Jews had in a particular country, that you could access that. But it really came with this idea of thinking to myself, well, if I'm going to conclude that Jewish rights continue to persist, right, how do I actually demonstrate that? So skip ahead through a couple of years, and graduate students doing graduate assistants doing research on over 100 countries. And this is what they did. We created categories that described these different legal arrangements, right? To try and sort of, in order to create this visual image, you had to have the categories. Mostly they, collected the data, classified it, and wrote narrative descriptions for every country where Jews live in the world. So our basic number was about 50, but anywhere that Jews could be found. And then to input the data into a mapping software, we used ArcGIS, in which a color would represent a category of a legal arrangement, and the darkness of the color would represent how many Jews were living in the place. These were the categories I ended up creating. I won't read through all of them. I think I started with 7, and then I ended up with 9 because some countries just didn't quite fit, and I had to create new categories. But just to sort of go through the first 3 to get an idea of what I'm talking about here. So category 1, religious freedom, separation, no state religions. The best example of that is the United States, right? You have a country where there is religious freedom, where there's officially separation of religion and state, there's no state religions, and very, very restricted rules on how the government can be involved in religion at all. Number 2, one of the officially recognized religious communities, that would be like Austria, right, or the United Kingdom. It's mainly countries that have one state religion, and then other recognized religious communities that have official religious communities that have official means to receive funding, etc. Number 3 is official neutrality with freedom of religion and room for public funding and recognition. So this would be like Canada, like France, which I actually would not put in number 1, right? Because there's official secularism or there's official neutrality. However, there aren't the same sort of restrictions preventing the recognition of official communities by the government or even subsidizing them. And so on and so forth. There are variations, but that's just to give you an idea of how I tried to create this sort of way of visualizing these relationships. Stupid face ID. Okay. And I tried to keep it, really simple. So this is the sort of the overview of what it looks like. It's essentially finished. I'm editing a lot of the narrative, and checking the narrative, and that takes time. But hopefully we'll launch soon. But this is what it looks like on a browser, right? So you can see that on the left you have the map, which can be moved around, and on the right you have a sort of index of categories. And so if you look, you can see how these kinds of relationships are grouped together, I suppose, geographically, and sometimes not. And I want to give you a few examples of how it actually functions, and how you can sort of see some of these contrasts. So we'll start with Austria. So it's sort of like a little video that I did, or an animation of me navigating it. So you move around, you find the country, you click on it, and it gives a description. You can also zoom to it, and it gives a full description of, it tells you what category I've put it in and why. And so it gives you a full description of what makes this a category 2 country. So in Austria, there are officially recognized religions and confessions, the relevant laws that are passed. There's a 1.1% income tax that's distributed proportionally of an officially recognized Jewish community, etc. So this is how somebody would navigate it. Then, there are also some sort of interesting outliers. So this is Bosnia and Herzegovina, which is category 7. So I had to expand the categories I first came up with because of countries like Bosnia and Herzegovina, which don't exactly fit any of them. So this is state religion with religious freedom, but Jews have no specified rights. So within Bosnia and Herzegovina, there's sort of an official role for Croats, for Catholics, for Eastern Orthodox, and for Muslims. And there's a Jewish community, but Jews don't have rights within that framework, and which actually leaves them with less than complete civil equality, because there are a number of political appointments that can only go to one of those categories, and Jews don't apply. To Morocco is another example. It's not in Europe, and I realized after we're talking about, I'm good for time, Europe. But Morocco raised an interesting problem, and there are a number of countries that raise this sort of interesting problem that I had, and that I would love feedback on, which is that whether this map should reflect the rights on paper or the rights as they exist, right? And largely, I have taken to having them reflect the rights on paper, and then noting in the narrative how that doesn't apply. But Morocco is a very interesting case because officially it has religious freedom constitutionally, but it doesn't really. But within that system, there are only 2 recognized religious communities, Sunni Islam and Jews. So Jews are an officially recognized religious community with a recognized separate court system, significant non-territorial autonomy, right, within this system that claims to have religious freedom but doesn't. And there are lots of other examples of that. Egypt, Egypt, Jews are also an officially recognized religious community in Egypt, right, along with Muslims and Coptic Christians, except functionally, this is on paper only, right? Functionally, there are almost no Jews. The gray ones, the countries are the ones with barely any Jews, and it probably should be one of those countries. However, they do continue to have officially recognized rights on paper. Another example where this comes up is Estonia. I'm glad there's been so much talk of Estonia, where Jews have both national and religious rights as a result of the law that was mentioned from 1993, where they have religious rights and national cultural autonomy. So much so on paper that, really as I started off, Israel was sort of a category of its own, right? A place where Jews have both religious and national rights. But I almost thought to myself, should Estonia be in, does Estonia, the other country that goes with Israel? In the end, I decided it's the other country that goes with Sweden, where Jews also have certain linguistic rights, and it looked a little bit more familiar. But one of the questions I had for the Estonia specialists, in terms of how I approach this map is, how much do Jews even know that they exist, right? That this particular law, right? So doing my research, I know that they have a community center, they have a school, I'm sure it's government subsidized, right? But really within a sort of similar framework to like Austria in terms of as a recognized religious community, I don't know that they are aware or how this national cultural autonomy functions at all, but it appears on paper. So it interests me. The last sort of example that I'm going to show you is, no problem, relates to something else I wanted to map, which are substatus rights. A few examples of places where Jews within states, right, have considerable sovereignty that is both territorial and non-territorial. And again, there's a problem with exactly how one categorizes these things. So the example I'm showing here is of Palm Tree, New York, which is a city in New York of about 30,000 Hasidic Jews that has essentially a total overlap between municipal and religious functions. The other examples I'm using for the sort of substated rights drop pins are Birobidzhan. Again, it exists on paper still. It doesn't in any way exist functionally, but it's still there on paper. Krasnaya Sloboda, if anybody knows about Azerbaijan, I'd love to talk to you about it because it fascinates me, but I don't know how perfectly this works, but it interests me. And the other, a region of substatus rights, the best example being the Palestinian territories, where clearly Jews have established communities outside of a state framework with both territorial and non-territorial autonomy. So that's the project, and I guess just with my remaining few minutes, I could just tell you sort of about what my analytical impressions are, what the discoveries are of having put this all together, this being the map as it exists right now. And there are a few. One, I would say that there's diversity. None of the interesting thing researching all of these countries is that there are no two identical systems. Every system has its own quirks, and there's diversity within each system. But also globally, you can start to sort of understand concentrations of models. For example, clearly in Europe, the dominant model is one in which Jews enjoy, in most places, rights as a recognized minority. And I've tried to sort of categorize both sort of pull out the analysis, both where Jews live under which systems and how many systems exist, or how many of the countries that Jews live in fall into those categories. So it's not surprising. Most Jews live either in the United States or in Israel, so most Jews live under a system of number one, or what I called number five, was essentially a national and a religious group. But if you look at the number of countries where Jews live, right, most countries where Jews live are actually either number 2 or 3, basically systems in which they are neither, have sort of total political sovereignty or complete separation, but, are more like Austria, right? So that's sort of the analysis that I've drawn up. And to just conclude, because I think I'm at that point, right? I would love guidance and I would love feedback from people who are working on different aspects of this. And actually, this sort of grew, as these things tend to, into a bigger project. I asked my university for money to expand it, but of course to get that money, they want me to be interdisciplinary, which was a great thing. So I had a colleague from the law school join this project, and she hired her own students who created a map of indigenous religious and cultural rights, which are different from territorial sovereignty that they exist in a lot of places. And they've actually since submitted this to the UN Special Rapporteur on something. And then we're going to have a third map as part of this project on minority language rights. And to try and sort of create both this encyclopedic resource and a way of sort of visualizing these different legal relationships. And that's it.